Hi. If at all you receive a blank check signed by the drawer, and if you are a complainant, obviously the remaining details in the check, like the name of the payee, that is the complainant's name, the amount in words, amount in figures, date, whether it is account payee or crossed check, all these details are to be filled by the drawer, that is the person who writes the check. But in certain circumstances, blank checks are issued with a signature. I will not go into the kinds of circumstances where the blank checks are issued. This video shall be limited to the legal validity of a blank check. What happens when a blank check is given? Will it fasten any liability on the issuer of the check or the drawer of the check? In the recent Supreme Court judgment in Oriental Bank of Commerce case, Supreme Court said that the blank check is perfectly valid and the details on the check can be written by anybody. It's a strange decision, but there is a logic behind it. Because the purpose of giving a check is based on a presumption that there is a discharge of liability or a debt towards the complainant. No check shall be issued without any discharge of liability or a debt, without any purpose, without any loan. No check will be given. If a check is in the hands of the complainant, it can be for the discharge of debt or liability. Otherwise, it might have been stolen, it might have been lost, or it might have been misplaced. Other than this, why will a check go into the hands of the custody of the complainant from the custody of the accused? It's very rare. Court will not believe that it just got wings and flew into the hands of the complainant. No, it will never happen like that. There will be a reason, there will be a relationship between the complainant and the accused, and when it is damaged, they come to court. So the point here is, even though you give a blank check, even though complainant is writing the amount of his choice, which may include interest or whatever the fancy amount he may write on the check and threaten you as a drawer, the power in the hands of the drawer is the liability or the debt. If you don't rebut that presumption, if a check is given, a presumption is raised. So you have the tool is in the hands of the drawer, that is the person who writes the check, about how to rebut. There is a reason. You have to prove that reason why you gave the check. If you have taken a loan of ₹1 lakh and 10 lakhs was written because you issued a blank check to the complainant, to the payee, now you have to rebut that 10 lakhs. You have to oppose that 10 lakhs. You have to disprove that 10 lakhs. It is an opportunity given to you, to the accused or the drawer or the writer of the check. If you don't utilize that opportunity, if you don't rebut that presumption, then the purpose of the presumption is lost. So law is always balanced between complainant and accused. Even though you give a blank check, complainant cannot become successful if you are successful enough to rebut the presumption that is given in the law to the complainant. So complainant side, it is presumed that there is a debt, and you have to disprove whether there is a debt or not. You have to dispute the quantum of the debt. You can disprove the quantum of the debt. You can disprove the type of liability, the quantum of liability. It is in the hands of the accused. So accused has adequate remedies, even though if he is giving blank check, even though it is written by the complainant, even though the writing doesn't match with that of the accused, even though enhanced amount is written, even though third party writes the check, third party writes the date, third party creates the circumstances, complainant creates the circumstances, even then accused has the right of defense, that is rebutting the presumption of issuing the check. So hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.